Yes, there are times when someone has passed away and they don't have a will in place. Actually, there are a lot of people in the United States who, for whatever reason, have not set aside the time to put together a will. And you may find yourself now as the administrator of an estate, and there may be property involved that either needs to be sold to take care of some of the debt that's in the estate, or needs to be sold so that the funds or the property can be liquidated so that heirs can receive a portion. I'm Courtney Rollins, the Life and Transitions Experts host and also moderator of the Life and Transitions Experts Facebook group. We're helping folks go through and make probate and estate planning easier while making income and wealth through real estate. It's one of my primary ways of finding folks who need support and finding property that's involved in there. And whether I'm the buyer or offering some other solutions for you or the family, I hope that you find this content and the service that we provide helpful. And so today's content and almost all my content comes from real life situations where people need support and need help. And I turn it into content so that I know if one person, two, three people are asking the same thing, that it can be helpful to other folks. So without having to go to, too many different places, you can look this up and hopefully guide you in the right direction. Now, I am going to share, as I always share, that I'm not an attorney or giving any legal or financial advice. I am just sharing my experience, and hopefully, it can be helpful to folks, practitioners, people who do the same work that I do, and or people who are actually going through the process. So today, let's take a look. All right. Oh, I thought I had this up already, but we're going to take a look at when you need or want to sell any really property, but particularly real estate and real property, but there is no will involved. Okay. So probate is the process of settling the affairs of someone who's passed away. If you die or pass away, or if someone passes away with debt or property in their name, there has to be a legal instrument or legal process to take that out of the person's name and make sure that those are all addressed. And that is often probate. There are legal instruments you can put in place to avoid probate, and I highly recommend you do so. If you need any support, I have tools and connections with estate planning attorneys and or other resource that you can actually set it up for yourself so that you are not putting your family through the situation. And please know that even if there is a will in place, the will has to still be go through probate. So there are ways that you can things that you can do, such as trust and other legal designations that allow a property to not go through the process because it is long, it is public, and it can be very expensive. So when someone dies with a will, that's means these dies with testate. They die with a testimony. That's why it's last will and testimony. When someone passes away and they don't have testate, it's intestate. They don't have a testate. So that person passed away. There's no valid will or there isn't a will in place. It is subject to intestate law. And so intestate law states when a person dies without a will, property is divided between the surviving spouse and or children. And then there's other orders involved depending on the nature of the people who are still, living and around. All right. And so, again, just disclaimer, I'm not an attorney or anything like that, just letting you know. And so today we're just going to look at certain things that you need in place. The 4 or 5 real things that you need is to notice the creditors if you are going through the probate process, an heir affidavit to show who all the heirs are, renunciation of benefits if someone's decided not to receive funds, and receipt of benefits from folks who receive the funds, and of course the transfer of titles. So yeah, notice the creditors. There is going to be a part of the probate process if it's a large estate, which most probates are, where you have to send to a verified uh, publication that has a certain bandwidth, and you can check with your state office, or whichever county you're in, and pretty much any mid to large publication will do that, show them the death certificate. They'll set it up for you, and you have to at least have it run at least once. Notice creditor has to run for a total of 4 months, but you have to at least show, you have to have the affidavit of notice to creditors to show. Most closing attorneys are going to want that to show that, okay, we already have it sent out. And so they'll know that at least the creditors have the opportunity to hear this, and that when you do sell the property, the proceeds, if needs to be, to go to and address the debt, is there will be available. All right. So do you need when there's no will, affidavit, air affidavit, and you can just really find one online, or again consult with a state attorney and put all the information in there. Make sure that it's notarized to show that this person died at the time of death, and these are the people who are their rightful heirs. And that's another thing the closing attorney will need. I've had this many times. When there's no will, at times you will have to make sure that someone who may have the right to a property sign a renunciation of benefits if they are signing, if they don't want any of the funds, or they can show that they actually signed off on the actual purchase agreement when there's a purchase agreement in place um, for this transaction and sale, and they will need to show that they received the funds if they did receive the funds. So receipt of benefits is if okay, we sold this, we all signed off, and this is how much money my sister got, this is how much money my cousin got, this is how much money whomever is has the right to it. Probably shouldn't say cousin, but don't want to confuse you. Just whoever has the right to the funds will need to show that they received it or that they renounced their right to receive those funds. The title will be transferred at a time. I had this as a car because I did a previous podcast or content on this when someone wanted a car transferred and they knew that their father wanted to go to a specific sibling, but he didn't have a will in place, and so um, that's there. But the as far as when you sell a house, the closing attorney will be able to make sure the new deed is set up and that on the purchase agreement that everyone who's needs to sign off signed off on the purchase agreement. Again, unless they renounce their benefits. All right, so this is me right there in the middle of the will. I support a lot of things when it comes to probate, particularly the non-legal side. And even if you need legal support, you can definitely reach out to me and I connect you with some great attorneys. Or on the, especially on the real estate side, that's our Jimmy Jam, and we try to help people as much as we can and listen with big ears and put together a plan that hopefully helps make your the whole entire process and situation go more efficiently and smooth. I am Courtney Rollins with the Life and Transitions Experts Podcast. That's LITE. Let your light shine. Cheers.